My presentation was based on the Dallas Cowboys cheerleaders versus the Pussycat cinemas. The argument in court is because Pussycat Cinema presented a pornographic film entitled Debbie Does Dallas, depicting an ex-Dallas Cowboys cheerleader, Bambi Woods, who was performing various sexual activities in a uniform that was awfully similar to the cheerleaders' current uniform that they had been wearing. They were basically suing for counterfeit infringement under the Layman Act of unfair competition and dilution of a trademark under New York law. The two big things that came out of this case was that they looked at the Layman Act and the copyright doctrine of fair use, stating that the federal trademark statute of the law in the U.S. it prohibits things such as trademark infringement, trademark dilution, and false advertising. Basically, the issue with that was that they were trying to say that they were sponsored by using a uniform that was very similar, and so that led to many people believing that the Dallas Cowboys chairman of the cheerleaders and the Dallas Cowboys in general had allowed or paid or helped fund the film to garnish more views, which was not the case, that they had no say in this and that they used their likeness to garner revenue that wasn't entitled. It basically puts a bad name on them as a company that they were involved in such an act, which was not the case. One of the procedural posture from the court, from the Southern District Court, granted the plaintiff's preliminary prohibiting injunction on the defendants for distributing the material and exhibiting the film. The defendant's motion to stay in the injunction and an order for expedited appeal was granted by the court. The issue that the defendants gave was whether a substantially similar depiction of a valid trademark in an adult film constitutes trademark infringement. So they're saying that they didn't really like the likeness behind it, but it wasn't that they were using it to garner a likelihood and to trademark their film based on the Dallas Cowgirls uniform. Basically, how it looked in court was that they were saying that it wasn't their fault, that they had just kind of gone with the uniform, not intentionally trying to copyright it, even though that the evidence kind of stacked up that it was an ex-Cowboys cheerleader that was then in this sexual act wearing a uniform that was very similar to what she was. It was just kind of creating an atmosphere in which there was a selling point. So basically the issue, and that was the main issue that came out of it that had to kind of revolutionize in the court, was that how do you substantially similar? Like, what depicts similar? There could be many different things that are similar without intention, but that's technically infringed right on their products. So how do you determine what is too similar and substantially similar? And that was kind of the fight and the debate for a long time in the court was this. The holding came out and basically said yes, because the uniforms worn in the movies and shown in the marquee had already determined by valid trademarks closely resemble plaintiff's uniform, and the public was likely to identify as plaintiff's uniform, saying that the similarity was too similar that if you just shown anyone, they would just assume because of the likeness that it was the Dallas Cowgirls uniform. And so that alone was their big point, was just saying that, you know, we agree that there is similarities and that there are similarities everywhere, but the fact that there's too many overlapping contributions, such as its next cheerleader, and the uniform is too similar. They were trying to disagree with it, with the defendant's assertion that the uniform is purely functional, but the court turned around and said that it wasn't, that the combination of unique materials, colors, and schemes was what made it so obvious that, you know, they had a blouse, a mini skirt, and just the color ranges with the white top as well, that they just all collided with the same similarities that were just out of the way and too deliberate to be made up. And so that was their overall standing on the case. The court then moved on the issue of this case, as stated above, and just kind of like as I said before, the court's confusion with the requirement of the Layman Act just basically said that it was too narrow, too similar, and too common to be kind of an accident. the trademark was violated, and that AMAP played a big role in this case because of protect people and the company from this kind of thing, that it cannot be used against them.